So great. Good morning, everyone, and welcome to Small Claims, a practical guide to dispute resolution this morning. My name is Carrie Lee Auger, and I'm the Skills Development Manager here at Women's Enterprise Center. My role is focused on providing training and resources to support women entrepreneurs through workshops, webinars, forums like this, and resources that you can find on our website. Also, if there's a topic that you would like us to consider for a future forum or webinar, please be sure to fill out the follow-up survey and share your ideas, because we want to make sure that we are providing the content that's most useful for you as you start, build, and grow your business. So quickly, a little bit about Women's Enterprise Center. We are a non-profit organization devoted to helping BC women start, lead, and grow their own business. Our full range of services includes business loans of up to $150,000. We have access to an additional $100,000 through a partnership with BDC. And most recently, we have access to loans through the COVID-19 funding for an additional $40,000, which I'll touch on in just a moment. We also provide business advice, skills training, mentoring, resources, and a supportive community to help women entrepreneurs realize their business potential. And we do this from 3 offices located here in Kelowna. I'm based in Kelowna, Vancouver, and Victoria. Our passion is to empower women entrepreneurs to your business success. We're funded by the federal government through Western Economic Diversification, and we're part of a Women's Enterprise Initiative, which includes similar organizations in Alberta, Saskatchewan, and Manitoba, and other organizations across the country. And of course, you can always learn more at our website, womensenterprise.ca. So very quickly, we still have our wec.ca/COVID-19 page live and active, where you can find the most recent updates on resources that we can provide, government programs, updates to government programs through links, access to some recordings in different areas to support you as well as we transition to this, reopening of businesses and what that looks like. And the recently announced $40,000 loans for women entrepreneurs who may have not qualified for some of the programs already out there, like the CEBA or the wage subsidy and things like that. So we'll be sure to share in the follow-up email after this information on that program as well. And you can also find it on the loans page of our website. And this COVID-19 page is updated on a regular weekly basis to provide you the most accurate information as possible. So it's a great one to have bookmarked on your web browser. And then just quickly today, kind of the webinars 101. If I know most people are getting very familiar with Zoom, but I like just to remind people that we use the chat and the Q&A functions. My colleague Danielle, who is supporting us today, thank you Danielle, has used the chat to say good morning everyone and welcome. So hopefully you can see that. And as we're going through today with Jennifer, be sure when you have a question, do pop it into the Q&A or the chat because Danielle and I will be scanning those to make sure that we get as many of them answered as possible. Understanding that maybe, Jennifer will cover it automatically in the content that she has, but we don't want to miss out on anything. And you should be able to see those chat and Q&A features at the bottom of your screen. So today's session, it is my pleasure to introduce Jennifer Choi. She's going to talk to us today what to do if you're being sued or you want to enforce your own legal rights. So Jennifer is an associate in BLG's disputes group, and she's going to walk us through, sorry. I lost my notes on my screen, but that's okay. Jennifer's going to the disputes group. She's going to walk us through the various dispute resolution processes available in BC, from the Civil Resolution Tribunal to private arbitration. She's going to speak to the pros and cons of each process, and will provide some practical advice for litigating small claims matters, the most common type of small business litigation. So Jennifer is a dispute resolution lawyer with a practice in commercial litigation and arbitration. She understands that every client has unique needs and provides advice in strategic, practical, and efficient manner. Jennifer has a diverse practice, including contractual disputes, life sciences, and other intellectual property disputes, construction disputes, consumer class actions, environmental prosecutions, and information and privacy law. That's a great portfolio, Jennifer. She regularly assists clients with complex commercial and regulatory issues and has experience managing large commercial litigation and arbitration matters, which involve detailed legal analysis and strategic e-discovery project management. She's appeared before the Supreme Court and Provincial Court in British Columbia and has experience interpreting a variety of domestic and international arbitration rules. Jennifer has a PhD in biochemistry and molecular biology and enjoys working with expert witnesses, delving into technical evidence, and translating scientific issues into persuasive legal arguments. This is a great bio, Jennifer. It makes me want to have a TV show all around your practice because it sounds very fascinating. So first of all, thank you for joining us and welcome. And I'm going to hand it over to you to walk us through this practical guide to dispute resolution. And thank you so much.
Perfect. Thank you so much. Just a thumbs up if you can hear me. I was having some mute problems earlier. Perfect.
Oh, you sound great.
Great. Thank you. I guess just to start off, as is obvious, this isn't legal advice, but hopefully you'll be able to take away something from my presentation today that will help you if you happen to have a dispute related to your business or even a personal dispute. So as my bio sort of intimates, I do a lot of large complex litigation, but I also do a fair amount of sort of small claims, small business litigation. At BLG, we do try to focus on the client's needs and finding a very practical solution to a problem. So just taking you through my agenda. The first thing I'm going to talk about, oh, sorry, next slide. I'm not controlling my own slides. Thank you to Danielle for helping me with this. Unfortunately, I'm zooming from my phone today because I actually don't have a webcam on my desktop setup. Okay, so my agenda. So the first thing I'd like to talk about is litigation right for your dispute? That might seem like a crazy thing for a litigation lawyer to sort of talk about. You'd think that we'd be like, yes, let's go to court. And I do love going to court. But there are so many different types of disputes and litigation isn't right for all of them. So hopefully some of the things I tell you today will help you identify whether or not litigation is a path that you want to explore to resolve your dispute. Then I'll talk a little bit about picking the correct forum. There are different levels of court in British Columbia, and depending on what your dispute is about, there is a better place between the three of them to go to seek your remedy. Then focusing a bit more on small claims, because that is a very common type of dispute. For small to medium businesses, it's amazing how many people will have or will be a defendant in a small claim during sort of the course of their career. I'll be talking about starting a claim and defending a claim, hopefully giving you some tips and tricks on how to deal with that situation and pointing out a number of places where getting legal advice could actually be very handy for you, even if you decide to sort of do it by yourself, because small claims is that type of dispute resolution that is designed for people to move through the process without legal help. Then I'll talk a bit about mediation and settlement, a little bit about going to trial, and then some small updates about what litigation looks like sort of in a time of COVID. So is litigation right for your dispute? I'm going to start by telling you a little bit about what litigation is. So as I'm sure all of you know, litigation is a process for handling disputes in the court system. As I said, there's 3 levels of court in BC. Litigation is a very powerful tool that can be used to solve a wide variety of disputes, from contract disputes to someone defaming you by spreading falsehoods about you or your business. And when most people think about resolving a dispute that has become confrontational, I think that everybody's like, I'm going to take them to court. And I definitely have those moments too, where something happens, I'm like, ooh, just, and sue you. And then you sort of step back and you think, right? Is that actually the best way to solve this? At its most basic, litigation is a process through which each party to a dispute has the opportunity to tell its version of what's happened to a neutral party, who is the court. And then the court will decide which side has the more compelling claim. However, often disputes can be settled through discussions between parties before litigation even starts. And it can be helpful to retain a disputes lawyer to help map out non-litigation strategies for dispute resolutions before you actually take that last step and starting litigation. So litigation isn't actually the best means of resolving all of your disputes. So why is litigation not the right tool for every dispute? Litigation can be costly and time-consuming. It can sour ongoing relationships, and it's stressful. I think that if you've ever had to contact a law firm about your dispute, you'll find out that it's unlikely that they'll recommend litigation as the first option for resolving the dispute. And I think too that most good lawyers will tell you that it is a tool of last resort because it can be so costly and time consuming. Despite the fact that the government has taken a number of steps to increase access to the legal system, including the Civil Disputes Tribunal, and having sort of small claims be a more cost-effective and efficient manner to resolve smaller disputes, most legal disputes that are litigated in the BC Supreme Court, which is, I guess, sort of the highest level of trial court in the province, can take over 2 years to resolve. And further, even relatively straightforward claims can cost over $100,000 in legal fees from start to finish. As I said, litigation can also tend to sour relationships. Canada's legal system is what we could call an adversarial system, and that means that each side argues their side of the case, and then the judge makes a determination on who wins. Because this is a system that pits two parties against each other, it can lead each side to entrench and see the other side as the bad guy, making it difficult to have an amicable relationship moving forward. Litigation can be stressful. Depending on what level of court you're in, there can be complicated rules or procedures. Like I said, it can take 2 years to resolve. So that's a lot of your life that you'll be thinking of sort of, what is this dispute? Litigation might actually not be possible if your dispute is based on a contract that mandates a different form of dispute resolution. For example, arbitration, which I also practice. Many contracts stipulate that disputes between parties will go to arbitration rather than court. And that's something that you might have negotiated in when you entered the contractual relationship, or if you're dealing with a larger party on the other side, their standard contracts might have an arbitration clause in them. Arbitration can be really beneficial. It can be a quicker way to resolve a dispute in many cases. And a lot of times parties that have long-term relationships actually prefer to go to arbitration rather than litigation, because it allows them to resolve disputes in a faster manner, and then that can allow them to continue their contractual relationships with minimal disruption. So depending on your type of business, that might be something you want to consider looking into in future contracts. The last reason that litigation might not be right for your dispute is that even if you win, the litigation might not result in a meaningful outcome for you. So you might not actually be able to get the relief that you're seeking. If you're suing somebody who is bankrupt, you actually might not be able to collect on the damages that the court awards. So that's also something that you need to think about before sort of taking that step and initiating litigation. But there are many benefits to litigation as well. So litigation might be right for your dispute. I think that the main benefit of litigation is that it provides a structured process and court-mandated cooperation. So once you start litigation, you sort of get on this litigation train, and there's certain deadlines that the court will enforce along the way. And so if you're having difficulties getting the other side to engage and discuss issues with you meaningfully, then litigation might be your only course, because if you start the litigation and the other side still doesn't participate and engage, then you're able to get relief from the court that you can enforce on the other side, regardless of their level of participation. Even if the other side is talking to you, they might be uncooperative. And those court mandated deadlines that I mentioned will make it difficult for the other side to ignore you and force them to at least engage in some minimal way. Another real benefit of litigation is that it creates a public record. Anyone who's interested can look at the records of a dispute and get copies of what you and the other side have filed with the court, unless you have requested a publication ban and have had that granted by the court. This public record can be immensely helpful where the issues of reputation are on the line. So if the sort of bad guy in your dispute is spreading malicious falsehoods about you or your company, getting a judgment from the court that makes it clear that their claims against your lies can help rehabilitate your reputational loss. Additionally, there are measures that you can take, such as requesting the court to issue an injunction before you actually get to the final stage of trial that can prevent the other side from slandering you further while the process continues. Having strict rules of evidence is also a real benefit to litigation. So most parties to litigation rarely have all of the evidence that they need to prove their case, and they often require documents or information that the other side has in their possession. So litigation, and particularly litigation sort of at the BC Supreme Court, provides mechanisms for you to get evidence by requiring both parties to exchange documents during the litigation process. And having these documents isn't just important for proving your case at trial, although that's sort of the ultimate goal of getting them. Once you have the documents and you can assess what evidence you have, what evidence the other side has, experienced counsel can look at that bundle of evidence and use their knowledge of the case law and what they've seen through their experience to give you a real sense of what is your risk moving forward. So being able to see the strengths and weaknesses of your case is one of the leading reasons that parties move towards settlement. You realize your case wasn't as strong as you thought, the other side's case might be a little bit better than you thought, and you're willing to come to a settlement that both sides can live with. Another benefit of litigation is that it is precedent setting. So if you're a type of company that has a similar small dispute arise with maybe many different customers, for example, our banking clients often have multiple small disputes relating to fraudulent checks. It can be valuable to create a legal precedent that you can rely on in the future for future disputes that will arise for your business. Going back to that idea of rules of evidence, getting to see the other side, and creating a solid risk analysis, the potential for a predictable outcome is a real benefit of litigation. So those precedents that you are creating and other people are creating allow experienced counsel to look at everything and say, okay, 9 times out of 10, this is what happens. No guarantees, of course. You might have something specific about your case that makes it a little bit different, but we can say, if we take this to trial, we think that you have a strong case. And then finally, of course, the benefit to litigation is that you can get an enforceable result. Once you have your judgment, the court will help you enforce it to collect a remedy. So for example, once a judgment is rendered, you can move forward to garnish bank accounts, seize property, or compel certain behavior. So that can be a real benefit if you are dealing with an opposing party that isn't just going to sort of settle or pay up right away. So how do you determine if litigation is right for your dispute? There are many considerations that go into determining whether or not you should start litigation. As I mentioned, a lawyer will rarely recommend litigation as the first step. I would always recommend you get a consultation, because even if you have a short time with a lawyer just to get a consultation, they can help you get perspective on your dispute and explain some of your legal rights to you. So I've got a few resources up on the screen if you're in a dispute and you want to explore litigation as an option. So first, if you have a lawyer that you work with on corporate matters, they usually will have a colleague that they can refer you to. Almost all lawyers will give you a free consultation to help you determine if litigation is right for your dispute, if you fit with them and your personalities jive. So take advantage of that. There's also a lawyer referral service that's run by Access Pro Bono. I've got the numbers on the screen for you. And that is a half-hour free legal consultation. And then with the Access Pro Bono, if you get your consultation and you think, yes, I want to go forward, they have a number of different options for moving forward. Sometimes you will work with the lawyer to do an entire dispute, or there's often a number of what we call unbundled options for you to choose. So you can do most of the claim on your own and check in with the lawyer periodically to make sure that you're on the right track, to get the legal advice at those key points that you might need it. So if you get a consultation, there is no obligation to continue either with litigation or with that particular lawyer. So don't let that be a barrier to seeking a little bit of legal advice. It can go a long way. All right, next I want to talk about picking the correct forum. So which court is which? So as I said, there's 3 levels of court in British Columbia. There's the Civil Resolution Tribunal. Their website is on the screen. They deal with small claims disputes that are under $5,000, as well as strata property disputes of any amount, and societies and cooperative associations disputes of any amount. The second level of court, which most small businesses tend to encounter, is the BC Provincial Court Small Claims Division. They do many types of cases. If it's a civil dispute, they do have a monetary cap, and that is $35,000. However, if you have a dispute that is just a little bit more than that, and you think going to the BC Supreme is maybe too expensive or maybe too time consuming, you can always choose to forego the amount of money over $35,000 and litigate your dispute in small claims court. So small claims court doesn't deal with all types of claims. As you know, they don't deal with the really large monetary claims, but they also don't deal with sort of a number of more specialized claims. So small claims is mostly for claims for debts or damages, recovery of personal property, or performance of agreements, but tends to be sort of more simple agreements. And then the third level of court is the BC Supreme Court. That is the court of inherent jurisdiction in the province. So they have the jurisdiction to deal with any and all cases. If you have a case that would fall within sort of the small claims monetary limit, but it happens to be something that's really quite complicated, or you need the court to give you an injunction, then you can still litigate in the BC Supreme Court. And then there's 2 other courts that I'll just mention quickly. Most people never encounter them, and that's the Federal Court of Canada and the Tax Court. So the Federal Court deals with disputes relating to specific areas of law, such as intellectual property, trademarks, copyrights, and patents, and as well as immigration issues. And the Tax Court, as the name sort of implies, deals with tax. So if you're working with a lawyer, he or she will help you determine which level of court is appropriate for your dispute. But the different websites that were on the screen also can give you a lot of information. So Civil Resolutions Tribunal, I'll just go over this quickly. It's designed to be a very sort of quick and efficient way of resolving small claims under $5,000. So it provides a number of interactive online pathways to facilitate getting the dispute resolved, including facilitated negotiation and mediation. All of the services are available online, either on your computer or your mobile device. Generally, CRT processes are designed for parties without legal representation. And in a number of cases, you actually have to ask the tribunal for permission to have a lawyer represent you. So there are a few small fees in the CRT process, but it is designed to be inexpensive, and you can use what they call the Solution Explorer tool for free. So the one thing to keep in mind for the CRT is you have 2 years to make a claim through the CRT after the event that has caused your claim to occur has happened. So you don't have to sort of go into the CRT right away, but if something happens and you have a claim under $5,000, you'll want to make a note on your calendar saying that this is the last date that you can make a claim to the CRT. So the BC Provincial Court, like I said, the small claims court deals with disputes of up to $35,000. As I also said, you can elect to forego your claim in excess of $35,000 to fall into the small claims jurisdiction. One of the benefits of the court is that it's less expensive than the BC Supreme Court and is a bit less complicated because it is a court that is designed for non-lawyers to use, and it's just a little bit less formal. However, some of the features that make the small claims court a good forum to bring your claim can also make it a poor choice if you have a more complicated claim. Small claims court makes it slightly harder to collect evidence from the other side. Their streamlined process means that you don't get access to all of the rules of evidence that you would at the BC Supreme Court. And small claims also tend to have slightly more unpredictable results. And that, I think, is because the judges are very focused on resolving disputes and sort of getting justice for both sides. And they can tend to be more creative, I guess, in ensuring that the parties get to a solution that is just for both, rather than sort of following the strict processes that you would see in the BC Supreme. So once again, you have 2 years to bring a claim in the small claims court, and 2 years will be sort of a general repetition in all of the court levels. So the BC Supreme Court, I'll touch on this briefly. I think that this is the court that most people think of when they picture going to trial. This is the court that everybody robes up in. Thankfully, in BC, we don't wear wigs. We still say my lord, my lady, and all of the rest of the provinces think that we're hopelessly formal. But it is the court that you think of when you think of, like, say, Suits or Law and Order, although our lives are not half that glamorous. So it is BC Superior Trial Court. It's the court of general and inherent jurisdiction, and then it means it can hear any type of case, civil or criminal. And the BC Supreme Court also hears most of the appeals from the BC Provincial Court. So as I said, litigation at the BC Supreme Court is quite a structured process. It's governed by the Supreme Court civil rules, which provide a mechanism for parties to obtain evidence from the other side, add third parties, and do a number of pretrial things through applications that aren't available at either the Civil Resolution Tribunal or in small claims court. Another benefit of going to the BC Supreme is that more remedies are available to you. Being a court of inherent jurisdiction means that the court can fashion its own remedies in many cases and ensure that the party that is requesting relief gets something quite similar to what they're asking for should they win. Whereas, for example, in small claims, the court is more limited to what they can grant as relief, mostly giving monetary judgments requiring personal property to be returned. However, the negative, because the BC Supreme Court's process is so structured, it can be a bit difficult to navigate without legal counsel. There's a lot of options. And while that can be great, it can also be overwhelming. So there's many different types of applications one can bring for evidence or prejudgment relief, and determining the best course of action without having an experienced advisor can be complicated and overwhelming. As I said, litigation in the BC Supreme Court can be expensive and time-consuming. A straightforward dispute with the BC Supreme Court requiring, say, 3 days of trial time will cost on average $100,000 to $150,000 from start to finish. However, most disputes actually don't go to trial. I would say that maybe 5 to 10% of all disputes will actually make it to trial, and a lot of parties are able to reach a negotiated settlement after they've exchanged evidence. So despite the fact that it can be expensive and time consuming, it might be the right choice for your dispute because of the additional procedural mechanisms, but also because once you have all of that evidence, it sort of gets that ball rolling to get to a settlement. All right, so I'd like to zoom in a little bit on small claims and talk about what starting a claim would look like. So most small to medium business disputes are resolved through the small claims court. And I'm just going to take you through a general outline of the steps that go into starting a claim. So once again, if you're considering starting a claim, I do suggest that you speak to a lawyer to get his or her help with your notice of claim, since it is the sort of framework that will get your dispute going, but also the framework through which the court will look at your issues and resolve the matter for and with you. So as you can see on the right-hand side of the screen, there's a form, and this is the notice of civil claim. So this is how you start a claim in small claims court. It's designed for people who are not lawyers. And the main pieces of information you need to present in the document is who you are, who you're suing, what happened that led to the lawsuit, and what you're asking for. So filling out the claim is straightforward, but once again, it's something that you should spend a lot of sort of time and thought on because it is the framework for your case. So in the from section, this is your information. So you put who you are and where you can be reached. During the process of litigation, if your address changes at any time, you can also change that with the court using what they call the notice of address form. In the to section, you'll put the information about the person you're suing. So this is a place that you have to be quite careful. You need to be careful when you're naming the defendant. The rules about names at the court are very strict. If it's not exactly right, you could win your case, but be unable to collect a remedy. So for example, if you were trying to sue me, heaven forbid, but you wrote Jane Choi, unfortunately, even though you might win against Jane, that's not me. So you won't be able to collect your remedy from me. So even if you plan to go through the small claims process without a lawyer, it can be worthwhile to get legal advice at the stage of deciding who to sue. It might be very straightforward, or it might be a little bit more complex. Do you have a dispute with somebody in their personal capacity or in a business capacity? Does this business have multiple related entities that you might want to sue? Is there a corporate head office somewhere that you should be taking into account? In the next section, what happened, obviously this is where you can tell the narrative of what led to the dispute. In general, I would recommend that you tell your story in chronological order. Even if there's multiple discrete claims, you would tell sort of story A, start to finish, then story B, start to finish. I think one of the things that is quite difficult in presenting a claim is because you have lived it and you know what your grievances are. For you, it seems very straightforward, but the court, who has no idea who you are, who the other side is, and what's gone wrong between you, will need to read your narrative of what's happened and get a clear picture of what's going on. So it's really important to be clear in the sequence of events. Using straightforward, plain language is the best. There's no points for prose. Even as lawyers, we're told to lay off the legalese. The court doesn't want to read it. The other side doesn't want to read it. Just tell us what happens. It is a small amount of space. So if you need more space, what we do as a trick is we put in C Schedule A into the little blue box there, and then you can attach a longer version of your narrative as Schedule A to the notice of claim. And this is one of the places, as I mentioned, that many lawyers are willing and able to help. This is sort of one of those key moments where if you're only going to get limited legal advice, I would advise that you engage it now, because this is a point where the lawyer will hear you tell your story and help you sort of piece together the puzzle of your dispute so that it goes to the court in the most persuasive way possible, and so that you can really deal with your claims in a strategic manner. There might be something that for you emotionally is very important, and I think that that is definitely important to have in the claim, provided there is a real legal solution to it. But there might be some aspect of your claim that is less emotional, but is maybe a more persuasive argument. And so the lawyer will be able to help you figure that out. The next step after you fill out your entire claim is filing the form. So once you go to file, you have to file at the small claims registry nearest to where the defendant either lives or carries on their business. There's a small filing fee. I think the most, if you have a claim over $3,000, it's $156. So like I said, small claims is a more cost-effective court to litigate in. So after you serve the notice of claims, the notice of claim, and there's a guide online that small claims serving documents that's really quite helpful. The provincial court does a really good job of putting out guides to help navigate the process. So after you serve it, the defendant will get it. The easiest way to serve is by registered mail. If you don't want to use mail, you can serve the defendant personally by handing it to them. If the dispute is particularly contentious, you might want to consider hiring a process server. You could also ask a friend to do you a really big favor and go serve your claim for you. But there are professionals who do this, and that can also sort of help keep the level of tension between you and the other side down. I don't think anybody wants to be served with a notice of claim. So if you go and do it personally and the dispute is quite contentious, that might impede any negotiations going forward. So something to think about. So after you file your claim, you serve your claim, then the defendant might just reach out to negotiate and settle. Sometimes starting litigation is strategic, and it's just to get the other side to engage with you. The defendant might file a reply, which I'll talk about next, or the defendant might do nothing, in which case you can move and get default judgment against them. One of the important things to know after you file your notice of civil claim is that you have a year to serve it on the defendant. So I was sort of talking about those 2 years that you have after the event leading to the dispute, that you have to file your notice of claim. So what you might want to do is, going along thinking, do I need to go to litigation to resolve this? And your time in that 2 years is running short. So you think, okay, maybe I need to preserve my rights and file something. So you can file that with the court and continue talking to the other side, or continue to explore your options, because you have a year after filing to serve. And just because you file doesn't mean you have to continue with the lawsuit. You can file your notice of claim and settle. You can file your notice of claim and realize, you know what, the time and energy isn't worth it. I'm better off focusing on my business. So this is a tool, and it doesn't mean that you're sort of on the litigation train going forward and having to commit. So what if you're defending a claim? Defending a claim is definitely less pleasant than starting a claim. You're unfortunately not in the driver's seat. So the number one thing when you get served with a notice of claim is do not ignore the claim. Absolutely do not ignore the claim. Once you get the notice of claim, you only have 14 days to decide what to do and file a response. It's a very quick turnaround, and being sued can be stressful, and it can be very sort of natural to want to put it aside and think about it later. But if you ignore the claim, the claimant can get a judgment against you just as if there had been a trial. So if you take nothing else away from this presentation today, do not ignore a claim if you're served with it. So if you agree with the claimant, you can pay directly to the other party or arrange to have a consent order filed with the court registry, so that everything sort of is tied up neatly in a bow. They started the claim, you settled the claim, the court knows that you settled the claim, and off you go to do more important things with your business and your life. If you agree that there is some money owed, but you can't actually pay the entire amount at that time, you can ask the court to set a schedule of payments that is more manageable for you and your business. So if you don't agree with the claim, then you fill out the reply that was sent with the notice of claim, and you file that with the court. There's a number of different reasons that you might disagree with the notice of claim. So your facts might be different than the claimant. You might read the notice of claim and think, who is this person? And this is not me. Or you might say, I know this person and this is absolutely not what happened. You might agree with the basic facts, but disagree with the amount that's being claimed. Or you might believe that there's someone else responsible for the wrong that the claimant is alleging. So for example, if you had a roofing company, and I know absolutely nothing about roofing, so this is a very basic example, but if you had a roofing company and you installed a roof, and the client comes back to you and says, my roof is leaking, you did a shoddy job, I'm gonna have to have it redone, you owe me $30,000. And you believe that you did a really good job installing that roof, and if there was a problem, it must have been with the roofing materials. And so the person who's actually responsible for this leaky roof is the supplier of those leaky roofing materials. So if that's the situation, then you'll want to file a third-party notice. And that's basically the equivalent to starting a claim against that third party, who in this example is the roofing material supplier. So that could be something you want to do as well. So I'm going to take you quickly through filling out the reply, just so that you sort of know where things go. So the reply is the answer to the notice of claim. 2, clearly where you put the name of the claimant. You can simply copy their information from the notice of claim. From is your own information. The claimant might not have gotten your address right, and that's not a good thing. Make sure that you correct your address in your reply, because this is where the court will send all of your follow-up communication. So you want to know, you want the court to know where you're going. Dispute, this is where you tell the court what you disagree with in the claim. You fill it out basically how you fill out the notice of claim, what happened section. Once again, be clear, chronological is great, straightforward language. You can agree and disagree with certain parts of the claim. Say you agree with claim A, sure, you owe the other side $5,000, but you didn't damage their sofa or their carpet. So you can disagree with part B of their claim. There's also a section in the reply for a counterclaim. So if the claimant did anything that you want recompense for, that's the place that you would put it. Once again, getting legal advice at the stage of the reply or the counterclaim, I personally think is a very good idea. Just like the notice of claim is the frame for the claimant's side of the dispute, the reply will be the frame for your side of the dispute if you're the defendant. This is an important place to get advice to make sure that your arguments are persuasive, well thought out, and sort of framed in a manner that will allow you to either settle the dispute through negotiation or will allow you to present a strong case at trial. So once again, you must file your reply no later than 14 days from the day that you were served with the notice of claim. So for example, if you were served with the notice of claim on the 1st of the month, and let's say that that's a Friday, you would count 14 days from that day, including weekends, and the last day to file the reply would be Friday the 15th. So as soon as you get that notice of claim, make sure you mark that down on your calendar. This is the day that this has to go in, the reply has to go into court.
And Jennifer, if I can ask quickly, do you also recommend getting a consultation or speaking to a lawyer on this reply piece?
I definitely do. I think a lot of times when you are faced with a dispute and you're on the side of being sued, you can really sort of shut down and think, this isn't true, this didn't happen, and you want to deny everything. And a lot of times denying everything can be the right response, but you'll want to find out sort of what is the best way to say, argue that it wasn't my work roofing, it was the roofing supplier's materials, or to maybe agree that there might have been some small problem, but absolutely it couldn't have been $35,000 worth of damage. And so having somebody who's not emotionally invested and not sort of stressed out about the process, walking you through and being a sounding board for you, I think can be immensely valuable. So what happens after you fill out your reply? So you're gonna have to serve it, just like the other side had to serve their notice of claim. And you actually serve it by just filing it with the registry, and the registry will take care of the actual process of serving for you. If you have a counterclaim, then the claimant will have a chance to reply to your counterclaim. But if there's no counterclaim and it's just you and the claimant, the next step will be for the court to schedule a settlement conference for you. So that will take me to settlement and mediation, and keeping sort of an eye on the time, I will talk fast, even though I think that this is a very important part of the entire small claims process. So settlement is encouraged at all times through the court process. Your lawyer, if they're a good lawyer, will always tell you to think about whether or not settlement is something that you could live with, and ask you what is the minimum thing that you would be happy with to walk away. Because once again, litigation is expensive, time consuming, and stressful. So if you have something that you can live with and then the other side can live with, it might be worth it to agree to whatever that minimum happens to be, and then for everybody to sort of walk away. So the court encourages settlement. I would encourage settlement in appropriate cases. And it's something that you should keep in mind at each and every stage of the process. So at the settlement conference, you'll go and you'll have a conference that's facilitated facilitated by a judge of the provincial court. They're not going to be acting in sort of their judge capacity at the settlement conference. They're there to facilitate settlement discussions, and then if settlement isn't possible, help to get both parties prepared for trial and to make certain orders that will allow both parties to get the evidence that they need, set witness schedules, set a date. One of the important things to bring with you to a settlement conference is your calendar, because if you don't settle, the court will want to set the date for trial. So at a settlement conference, one of the other important things to bring with you are all of the documents that you think that you will need at trial to prove your case. And in the small claims process, the settlement conference is one of the opportunities for you to see the evidence that the other side has and to give them the evidence that you have. And once again, that will help the settlement. So it does neither you or the other side a favor if you sort of are holding back your good evidence or not telling them the entire story, because once all the cards are on the table, you can make a better assessment of whether or not settlement is possible. So when you're bringing your documents, it's good to bring organized copies of documents. I've definitely been to settlement conferences where you sort of get a box of documents from the other side and you think, oh my goodness, this is going to take me a long time to sort through, because they've sort of photocopied things and they've just kind of all shoved it into into a container. So it's helpful to the other side and to yourself if you do a little bit of organization on your end before you go to the settlement conference. So if you're the claimant, you have to prove liability, and that is, did the defendant do something to wrong you and the amount that you're claiming? So your documents might consist of the contract between you and the defendant and your receipts that you have showing that there was some damage, and photographs of what happened. Was your carpet ruined? What does the leaking roof look like? If you've talked to the people who will be your witnesses, it's great to bring a short summary of what you think that they're going to say at trial so that the other side gets an idea of sort of the case that's coming against them. And for you, so that you can put everything in sort of logical order in your head, a good way to organize your evidence is in sort of a table of facts in one column with the pieces of evidence that you'll use on the other. So you can say, fact, roof is leaking. Your evidence will be, say, your photographs of the roof during a rainstorm, the puddle on your carpet after. The fact is that your carpet was ruined and it's going to cost you $25,000 to replace. The evidence would be the picture of your ruined carpet and maybe a quote from a carpeting company saying that to rip out and replace your carpet will cost $25,000. So the last thing about the settlement conference is that it is mandatory. So if you don't show up, the judge might order that the other side wins their case. So similar to the reply, do not just let the settlement conference pass you by. Make sure that you show up, make sure that you're prepared. The other option in small claims, and this isn't a mandatory option, is mediation. So the court won't make you go to mediation, but it can help you resolve your dispute prior to trial and without going to trial. Oh, can we actually advance 2 slides, I think? Thanks. One more. Thank you. So once, like I said, mediation is not mandatory, but it can be helpful because it is a structured process where you will have a neutral third party who will engage both sides to discuss their case and shuttle back and forth offers. So it can be something that is a little bit less formal than the settlement conference because it won't be before a judge, but useful in hammering out sort of where is the other side's pressure points, what are they willing to give, and what are you willing to give. So the downside to mediation is that it's not free. Both sides will share the mediation costs equally. Mediate BC is a great place to start if you're looking at going to mediation. And the other really important thing about mediation is it's without prejudice. So you can talk during mediation, and if the dispute ends up going to trial, the judge won't be told about anything that happened or was said at the mediation. And so when you're gathering your documents and preparing for mediation, there are a number of questions that you should ask yourself. What's the best result that you think you can get? What's the worst result that could happen? What is really important to you in the dispute? What do you think the other side's concerns are, and how can you address those concerns? So I was recently involved in a really productive mediation for a small matter. I think it was about $50,000. And the primary thing that the other side wanted to have was to be able to be heard. They'd felt that they hadn't been heard during the process thus far. And so they were pushing to trial really aggressively. And we suggested, well, let's see if mediation will do anything for us. So we met with the mediator and we had a couple of hours of unproductive negotiation. But because the mediator was going between us and the other side in 2 separate rooms, the other side told the mediator, like, you know, I'm so angry. They're not listening to me. I feel like I haven't been able to tell my story. So the mediator came to us and said, would you be willing just to hear them out? And we thought, okay, I mean, we've been here for a couple hours anyways, what's a little bit more time? And so we heard them out. And although we didn't agree with how the other side characterized a lot of the facts that had happened, after they'd gotten it off their chest and we listened and we, you know, understood where they were coming from, we were actually able to come to a settlement. And so we wrapped everything up that day. And it was the best result you can hope for out of mediation. So if mediation is suggested, I highly recommend that you take that opportunity. Okay, and the last thing I'll talk about quickly before taking brief questions is preparing for trial. So trial can be complicated and stressful, so it's important to keep organized. You need to know what facts you need to prove, what documents will you rely on, who are your witnesses. Once again, that table that I spoke briefly about before can be super helpful just to keep everything together. If you have witnesses, make sure that you prepare them. What questions will you ask them? What questions do you anticipate the other side will have? Obviously, being a witness isn't quite as stressful as being the claimant, but most people aren't used to sitting in front of a number of people and answering questions for a couple of hours. So I think that having a practice session with your witness can be really, really helpful. Preparation for trial is also a place that I think that getting a lawyer to help you can be very beneficial. Most people don't go to trial a lot. And so, I mean, I hope you don't go to trial a lot. Whereas most legal counsel who work in disputes have gone to trial multiple times. They sort of know what to expect. They've seen it done before. They've done it before. And so they'll be able to give you little tips and tricks that can be invaluable when actually being in court. And if nothing else, they can tell you sort of what to expect, how to prepare, and help you brainstorm questions that you might want to ask the other side's witness, questions that the other side might ask your witness. So investing in a few hours of legal time can be really valuable before heading to trial, because trial is show day. That's when you're going to talk to the judge, and that's where everything's on the line. Another thing that I would consider, and I do this myself, being a junior litigator, is sort of having a mock trial in front of, for me, it's my colleagues, but for you, it would be friends or family, where you invite a mock judge to find the holes in your argument. Having a run through ahead of time, as with anything in life, can be really beneficial. And then lastly, if you have a really good reason for being unable to attend the trial date, trial, you can ask the court to postpone or adjourn the trial. So if you are suddenly ill or a family emergency comes up, you can get the trial postponed. So just some quick things about COVID and litigation. So litigation currently does look quite different, as the entire world does during COVID. Our court system is really based upon sort of face-to-face hearings, being able to confront the side that has wronged you and to tell your story to the court. Obviously, with social distancing, that's becoming something that's not possible. So the courts have really sort of moved towards a more telephone and online-based dispute resolution system. And unfortunately for BC's court's not particularly technologically savvy. They're a great court, but the courtrooms, I think, have 3 plugins. And so they're just not really set up for the 21st century. So that's actually been one of the major challenges that we've faced during COVID. Another challenge has been serving documents in person has become more difficult. A lot of businesses are shut down or they have different hours. And so people can be harder to find. So if you're thinking of starting a claim, keep that in mind, that some of the steps can take longer than you think that they would, because COVID has just made the world such a different place. Evidence may also be harder to gather. If one of your key witnesses is, say, in Florida, they might not be able to come up here and testify. So that's going to be something that you're going to have to think about. Hopefully, by the time, if you're starting a claim now, by the time you get to the end and you need them at trial, we'll be able to travel again, but I think that that's really up in the air. And then COVID delays again, it's taking longer for the courts to schedule hearings. And so the courts have admitted there'll be lengthy delays. So once again, if it's a dispute that you think you can settle, I definitely recommend talking to the other side and seeing if you can negotiate something out. And questions. I'm happy to stay for a bit longer if there's questions.
That's great. That was Fantastic information, Jennifer. Thank you very much. And we do have a couple of questions that come in, so we might go a couple minutes over, but if you're willing to stay, I'll ask away. So we did have two, just going back to your last slide, two different participants had asked about options when filing the notice of claim when they don't know where the defendant is. Is there a way to search for that person or find out that information?
Yeah, so if your defendant is a business, and if they're a corporation or a partnership, they'll have to be registered in British Columbia. And so you can actually go look at the corporate registry and pull their sort of head office location, or what they call their registered and records office location. And that will be an address that's just listed on the corporate document that you'll be able to get off the website. As a lawyer, I know that the website I go to for that information is called BC Online. I'm not 100% sure if you don't have sort of like legal resources, if that's the same place to go to. And that can be a great place, a great time to get legal help as well, if you need to track somebody down, just because the lawyer might have access to resources and or investigators that they've used in the past that you might not have. But once you get that registered and records office, you can actually just send your notice of claim to that address, and that's considered to be proper service. So that's my number one piece of advice. If it is a person that you're unable to find, that can be a little bit more difficult. A lot of times what we do is we hire an investigator at that point to see if they can track down last known addresses. Social media and Facebook can actually be really helpful. As a student, I did many a task that was see if you can find this person through their Instagram or their Facebook page. So creative out-of-the-box solutions are also really helpful.
Another good question here is, if I'm suing a sole proprietor, should I name the person or the business?
In that case, I think, well, they're the same person, so it doesn't really matter. What we usually do is we name the person in a personal capacity and then have doing business as, and then the name of the business. And
that covers both. That was my thought, but I'm glad you agreed, because I think, sole proprietor, you are your business. So it's kind of one in the same, but you can cover all bases by naming the person and the business. So that's great. Just going through again, I have another one. And again, going back to kind of that small claims, this question says, as a construction subcontractor, I've encountered several times where the development company won't pay. It's been more than 3 months during COVID time. Is there any way I can get them to pay other than sending invoice after invoice? It's a large development company and there was no contract signed.
So, especially because there was no contract, in this situation, I would advise you to get legal advice. One of the things that you can do is file a lien against the development or the property. So what that is that's a mechanism that's specifically designed for contractors and subcontractors to get paid in situations such as these. So it's a legal sort of encumbrance that you put on the property that then needs to be paid out at a certain time, and you can sue on that lien and have your invoices paid. So depending on how long it's been, what the project was, how much money it's for, there'll be various different steps that you'll need to take. So that's one of the reasons I would say that particular issue is a good place to go get a consultation. Their liens are finicky and tricky. They're great mechanisms for getting paid, but you do have to do the process correctly. So there is a remedy out there.
Step in that industry for construction.
Yeah, it's a very construction specific mechanism to get paid, and it's a very common thing that contractors and subcontractors do. Yeah, unfortunately. But it is tricky, so I would suggest at least talking to an experienced lawyer in that field about that.
Okay, another question, and I know you mentioned it briefly at the beginning, is how to handle copyright infringements.
Yeah, So I think depending on what your copyright is in, there can be various different mechanisms. If it happens to be something, for example, somebody's copying your website, there are sort of some self-help remedies that you can engage in, such as going to their domain host and complaining that there is a copyright issue occurring. If it's something a little bit more complicated, for example, you are a, say you're an animator and a certain amount of your animation has been stolen and used in somebody else's project, that gets a little bit more complicated. And so that's probably not something that I would suggest that you tackle on your own, just because copyright is something that can be done both in the provincial court and also the federal court, and the federal court is sort of the specialist court for it. But getting everything going, getting all your evidence together actually can be quite tricky, because even though you look at it and you know that it's yours and they stole it, if it's not an exact replica, then there's a lot of evidentiary steps that you need to go through to prove that to the court. So I think that that's something that I would also advise talking to somebody about, and seeing what that would look like if you went to litigation. Sometimes sending a simple cease and desist from a law firm can solve all of your problems. Stop doing this, we will see you. And the other side's like, okay, I'm gonna stop. And that can be a great first step. And that's probably the first step everybody would recommend that you take. But if you do need to litigate, I think that that's something that you should get specialist help on.
Okay, great. And then one quick question here in regards to dogs and breeders and being told that the dogs are healthy and they're not. So you've had all these expenses. This participant is asking, is it a good idea to go to small claims court? I've been told that pet owners have no ground to stand on versus breeders. So I don't know if you have any history or intimate knowledge of that specific question. I
don't have that specific question, but presumably if you were getting your pet from a reputable breeder, you would have had some sort of contract, even if it's an oral contract, or you sent them an email and they said, yes, your pet will be healthy, you owe me, I'm actually looking at a corgi right now, $4,500. And so that is a contract. And if they told you that they would give you a healthy pet and that's not what you got, then you might have recourse to the courts to sue for the amount of money that you paid, possibly not for your pet, but perhaps for vet bills that occurred. So I don't think that you have no remedy, but it's something that you'll have to go through your documents and sort of think about. But I would suggest thinking about it as a contract.
Right. Okay, great. So I'm just going to go back quickly and share my screen again. And I'm just going to pull up for everyone while I'm thanking you, Jennifer, the information on the loan that I mentioned earlier, which is great. And we'll send a link to this and more information in the follow-up email as well. But there are additional funding available for women that have not qualified yet for any of the government programs, and we're able to offer that to you as well. And if I just go back over here, get my slide, there we go. Just a few upcoming events as well for those of you that are interested, how to plan and launch a new website, which is of course very important in this day and age as a lot of things are moving to a more digital platform. If you're in a business and you want to know if you're export ready, that's another great webinar coming up. Again, once you've got that website, how to get the traffic there. And then one of our most popular sessions, we've run these a few times, is finding and bidding on opportunities with the Government of Canada. And Erin's going to join us again and bring in some of the COVID specific opportunities that are out there. So again, we'll send links to register for all of those events. So again, Jennifer, thank you. That was a very thorough but very easy to understand and grasp presentation. So thank you very much for all of the information you shared with us today as well. And to Borden Ladner Gervais and your Driven by Women series for partnering with us again this year to provide these excellent resources to our community. So thank you very much. Thank you everyone for joining us and for hanging on here as we answered a few questions. And I wish you all a good afternoon. Thanks everybody. Thank you, Jennifer. Have a great day, everyone.